Recognizing member Oak Bay Gordon Head.
Thank you, Honourable Speaker. I rise to take my place and continue my second reading speech to Bill 11, Civil Forfeiture Amendment Act. When I left off last week, I just completed articulating three specific examples wherein the application of civil forfeiture in the province of British Columbia had led to some issues that brought in that require some critical oversight as to how civil forfeiture operates. The first example I raised, just to bring some continuity to the speech, was with respect to a 74-year-old, Ellen New, who had the charges against her stayed. That was charges for possession of cocaine for the purpose of trafficking, but nevertheless, her home was ordered forfeited in 2013. Another example of inadvertent consequences with respect to the application of civil forfeiture in British Columbia was the example of David Lloyd-Smith's house. There, police showed up at his house and entered without a warrant. They found a couple of pot plants, and despite no charges being laid, the Civil Forfeiture Office sued to seize his home in 2011, 4 years after the initial RCMP raid. And in 2015, 8 years after the initial raid, the BC Supreme Court ruled that the rights of Mr. Lloyd-Smith were in fact violated. The third example I outlined was in the case of Mumtaz Ladha, who sued the Provincial Civil Forfeiture Office and the RCMP for pushing a false narrative and relentlessly trying to take her home. In this case, the police allegedly ignored witness testimony problems and pushed a false narrative of Ms. Ladha being linked to human trafficking in British Columbia. And the Civil Forfeiture Office then tried to take her multi-million-dollar home. The RCMP issued an apology and the claim has been settled. And the reason why I outlined these three examples is to provide a cautionary tale as to the application of civil forfeiture in British Columbia. As it stands today, we have some of the strongest laws in the country, and before us, Bill 11 purports to bring forward even stronger laws. And while much of this bill is not controversial, certainly aspects of it are with respect to putting the onus of proof onto the defendant, as well as some of the timeliness issues with respect to how fast civil forfeiture can move. You know, the examples were deeply problematic, Honourable Speaker, because they showed that the scope of the Civil Forfeiture Office is sometimes overreaching in its powers. And we don't know for sure, but I suspect that there are other examples, and what we're hearing about may be but a needle in a haystack. You know, the Minister has said that some of these problems can be attributed to growing pains, and that it's important that the Civil Forfeiture Officer is used in the spirit it was intended, which is organised crime and gang crime. And you'll get no argument from us here, Honourable Speaker, that it is important to ensure that civil forfeiture is used for the purposes it was introduced for, in particular to organised crime and gang crime. However, Honourable Speaker, this bill does not seem to do anything to ensure that civil forfeiture is used for organised and gang crime specifically, and not applied in broader cases. And in that case, I raise again the issue of the BC Civil Liberties Association, the Canadian Constitution Foundation as well. They've raised some concerns. I would suggest valid concerns, and the Attorney General obviously has spent some time working in the latter organization, or the former organization, and would recognize that he too raised similar concerns when he was there. And I bring these forward not in speaking in opposition against the bill, but purely as a cautionary note. We already know we have one of the most aggressive forms of civil forfeiture in the country, and we're proposing to make it stronger with increasing powers. And we also, again, I put that in the context of British Columbia has an outrageous money laundering problem, and frankly, we have not yet got to the bottom of it. So I bring these concerns and I raise them mainly as a cautionary note. The BC Green Caucus is supportive of the province taking measures to go after those responsible for money laundering and organised crime, but we need, at the same time, Honourable Speaker, to ensure that innocent British Columbians are not also targeted, and we'd recommend the Auditor General review how the office is operating and if it is achieving its objectives, particularly in light of these increased powers. I articulated in the previous speech last week a number of calls for review by members in Government Caucus, as well as external agencies, as to how civil forfeiture is operating. And I would hope we'd have an ongoing assessment as to the effectiveness of that office, not with any punitive goal in mind, but more to ensure that it's targeting that which should be targeted, which is organized crime and gang activities. You know, as I've said, we have a couple of concerns in the bill. We look forward to hearing government's explanations. Most notable will be Section 14, where the onus or the burden of proof changes in Section 14. If a suspect has an aftermarket compartment in their vehicle, for example, certain equipment or cash over $10,000, this is now considered to be proof of being an instrument or a proceed of illegal activity. You know, heaven forbid you be a type of person who likes to buy things in cash, and there frankly are people who do that. People from, you know, my father, my mother, my in-laws' generation, where cash is king. The notion of paying for cash is king. And it would not be uncommon with some people from, who hold that belief to actually pay for things in cash. And having $10,000 is not all that much these days, Honourable Speaker, in cash, certainly in many cases would not be indicative of it being proof that a crime has been committed and this is an instrument of crime. So we express some caution there. While I personally have never carried around $10,000. I do know people who have carried around $10,000 specifically to pay for cars, where they paid cash for cars and the cars was over $10,000. You might ask the question, why are you paying cash? And that's a legitimate question to ask, but it does happen, and certainly it was not money that comes from proceeds of crime. So not only does the burden of proof change, Honourable Speaker, in what was already a regime that simply needed the balance of probability, it also means that the defendant might have to implicate themselves to produce evidence to counter the evidence of the civil forfeiture officer. For example, an aftermarket compartment in a vehicle, that's like a hidden compartment in a vehicle, might have nothing to do with trafficking drugs. You might have bought a car from somebody who had the compartment. You may not be aware of it. You probably are, but you may not. You may just ignore it, whatever. But the reality is that can now be considered as proof of illicit activities, and it's not clear that, in fact, the burden should have to go on to the driver or the owner of the vehicle to prove that existing of that aftermarket compartment is proof of illicit activity. You know, maybe, for example, there's somebody who lives in their car. We know this is more and more common. We have students living in their cars. We have senior citizens living in their cars. And maybe in their cars, they might want to have a space where they protect their valuables. They have a locked or secret compartment where they put their credit cards, their birth certificate, their driver's license, maybe some other valuable goods, some jewelry. So that might be out of necessity. That's certainly not evidence that there is that the car or anything in the car is being acquired as an instrument or proceed of illegal activity. And so I would suggest that we must be cautious in putting the onus of proof on the individual as opposed to the actual accuser. And it's potentially problematic, and so we look forward, and I'm sure members opposite will also be exploring this further at committee stage. And I would suggest that is probably the most controversial aspect of this bill. Of course, there's also the regulation-making authority, quite a number of items in this bill, as is common in all bills government brings forward, is that a lot of what will be done is left up to regulation. One, for example, is the ability to prescribe what would be considered a piece of equipment relating to trafficking. You know, what does that mean? So who's going to make the determination? Cabinet based on advice, I suppose. But I would have thought we would have thought this through a little more before bringing it to the floor. But nevertheless, this bill, we believe, is something that is worthy of our support, and we look forward to exploring this at committee stage. To summarize my remarks on this, clearly, as you will know from question period, we have been raising this issue. We're profoundly troubled about what's been going on in the issue of money laundering. We are now being labeled a nation of money laundering by U.S. officials. This is not a terribly flattering label to be given, and so our caucus is profoundly troubled by this. So we are supportive of the inclusion of an addition of more tools to prosecute criminals in British Columbia, and we hope that this bill is used accordingly. While no one should benefit from the proceeds of crime, it's also important that we are vigilant in protecting the rights of Canadians and the freedoms of Canadians as well. And in particular, we must be very wary of the potential abuse of power that this legislation instills upon the Civil Forfeiture Office. You know, they've sought to obtain property from innocent British Columbians in the past, and we need to ensure that this does not happen moving forward, and that British Columbians are protected in the case that inappropriate civil forfeiture attempts are moved forward. You know, our caucus has heard from civil rights organizations, and we've heard from constituents about the concerns with regard to the issues that I raised here in the legislation. And as the official opposition, as government when they were in official opposition, also had similar and strong concerns about the Civil Forfeiture Office. But and ironically, one might say we're now moving to increase its powers. With that said, though, I suspect that government has now moved from a position of opposition to a position of government, open the books on the money laundering and realize just how serious this issue is. From the answers we've been getting from the Attorney General over the last couple of weeks, we're convinced he's taking this issue very seriously, and we're convinced that he finds this to be a very troubling issue, and that he's hoping to ensure that more and more tools are brought forward to allow his office, and the province of British Columbia to get to the bottom of what's been going on in money laundering. It is inappropriate, it is not right, and it is something British Columbians do not support, is people using the proceeds of crime to build monster homes and to leave that money there and have there be no accountability. So we recognize that, in fact, this bill does potentially give police and others more power to actually go after those who've committed criminal activities. We've also heard, you know, as I mentioned, from others about this legislation. You know, we recognize that there is some concern, but we are supportive. We're going to look forward to exploring this in committee phase, and I look forward to the questions and continued debate from members opposite. We believe, right as it stands, there is reasonable justification for the changes being made, but we hope to canvass this further at committee stage, and I look forward to listening to the further speeches at second reading. Thank you, Honourable Speaker.